To modify a custody order really depends upon where we are in a case. So if we're in the initial part of a case before the final judgment has been entered, if there is any change in circumstances that would make sense for the court to reevaluate whether or not it's in the best interest of the children to look at something different, then either side can file the paperwork with the court and ask the judge to reevaluate it. It should be clear that under California law, before the court makes a decision, parties are required to go to a mediator, and that can look very different depending upon the county in which the case is handled. Some counties are referred to as recommending counties. Those are typically bigger areas where the mediator is often a trained family counselor of some type, and that counselor is going to talk to the mom, talk to dad, in some cases talk to the children, and try to figure out really what it is everybody wants, what the goals and objectives are, and what's best for the children. If the parents are able to come to an agreement with the help of that mediator, then most of the time that mediation, that agreement is going to be adopted by the court. If the parties are not able to come to an agreement, then the counselor will make recommendations to the judge. Not always, but most of the time, the judge is going to rely heavily upon those recommendations and probably adopt them as the order of the court. The counsel, the attorneys for the parties can argue to the court why those recommendations may not make sense. And I've done that. I've done that successfully. It really depends upon the facts of the case and the situation. But sometimes we do see reports where the recommendations really are not the best course of action. And our job is to explain to the court why those recommendations don't make sense and to justify what alternative suggestion that we may be making to the court are the best course.